All rise. 75th District Court, back in session. The Honorable Michael D. Carpenter presiding.
Thank you, everyone. Please be seated. Right, we are on the record. People, State of Michigan versus Michael Vincent Roll, file 21-0420 SM. Counsel, identify yourself for the record.
Thank you, Patrick Swinsky for the people.
Peter Durant on behalf of Michael Kroll. He is seated to my left, Your Honor.
All right, today's time and date for the motion. This is the defendant's motion to review bond. Is that correct?
That's correct, Your Honor.
All right. And this one was about the legality or the constitutionality of the court's decision to use pretrial services in your motion. Is there anything else you want to augment with your argument, sir?
Primarily just discussion of the facts, I believe, is relevant, Your Honor. I believe the court knows my legal argument in my motion.
Okay. Do we have any witnesses for today, or is it just a legal argument, Mr. Schmitz?
Just an argument, Your Honor.
Okay.
Although I would, from a proof perspective, I would ask the court take judicial notice of a prior file that it sat on.
That's the domestic violence first
Yes.
offense? Yes, the court will take judicial notice of its own file.
16-0356 SM.
Okay. All right. Mr. Durant, your argument, sir.
Thank you, Your Honor. We're here today on defense's motion to ask for a modification of bond after having the court has ordered bond previously on April 11th, 2021 of this year. And those terms and conditions of that bond were done under MCR 6.106D as stipulations or as conditions for defendant to follow while he is out on bond that the court believes was reasonably necessary. Since that day and time, I believe there's been a significant amount of facts. I believe that there's been somewhat of a history that has been built up before today, specifically that defendant is working at about $23 an hour. He works in isolated locations as the foreman of a tree trimming and tree cutting crew. As such, he's required to travel long distances, work long hours, especially with the recent storms and the weather issues that have been going on, requiring him to work almost mandatory overtime, or it's called storm watch for his job, which requires them to work an additional amount of hours that is overtime. This has been new since the filing of this motion based on just the current weather that we've been having. I've been unable to file a supplement. As outlined in my motion, however, the defendant's full-time gross pay is about $3,680 per month. His net monthly income, however, is only about $2,836 per month approximately. He has expenses totaling $2,931 per month. I've outlined those expenses in my motion, as well as the fact that if the court needs any sort of verification of those expenses, defendant is willing to testify to those expenses. As such, you can see that there is a discrepancy and there's a current deficit working regular full-time wages. Defendant currently relies almost exclusively on overtime to make ends meet and to pay for the necessary expenses that he has incurred. Specifically, those extra expenses as required by J&A services to test for drugs and for counseling. Those are extra expenses that are not factored into this budget that are causing some significant financial troubles. Defendant is currently doing his best to pay for those services. However, based on the time requirement of showing up, he misses work. And when he misses work, that causes problems with the extremely tight budget as it exists right now. In addition to the mandatory overtime and the specifics of his job as the foreman, where if he leaves, no one can accomplish work under OSHA. So based on the fact that he is currently the foreman, he's required to be there for the crew to work under OSHA laws. And any time taken off of his job is actually significant, and it could damage not only his finances, but the finances of the minor child. We would just ask that the court, moving forward, modify defendant's bond such that he is no longer required to do substance testing. This is not a substance offense. There's only previous substance offenses include minor in possession, which are status offenses, which he legally cannot commit moving forward. Thank you, Your Honor.
All right. Mr. Schwinsky.
Thank you, Your Honor. I understand the financial restraint. I know that in the past, the court has made arrangements with various agencies to alleviate that. I understand that concern. My concern, obviously, is that this is not actually his first prior offense that involved substances. If the court would review the PSI from the previous case, it did show a history of alcohol abuse going back to age of 14. He was quite intoxicated at the last time he was convicted of domestic violence, and he was obviously a regular drinker at that point. And J&A did recommend at that time participation in alcohol substance abuse programming. So from that respect, there is a history, I think, that's sufficient for the court to order the substance abuse evaluation and testing consistent with the court rules ability to impose bond restrictions to ensure the safety of the community, which is quite clear within 6.106. So I'd ask that the court maintain those, not modify bond. As far as the frequency, et cetera, I leave that to the court's discretion. But I believe there's sufficient facts with respect to the defendant's history that makes that an appropriate bond condition consistent with the law, Your Honor. Thank you.
You follow?
Thank you, Your Honor. I can't speak to the specific details of the case, the PSI or such of the first offense. I wasn't the attorney in the first offense. However, I can speak to the specifics of this offense, and alcohol has not been a factor here. In addition to that, when Mr. Kroll does test, he tests negative for substances. He may have an alcohol problem, but he is currently not using alcohol. He's currently not using marijuana, despite any sort of previous showings of some sort of alcohol dependency or abuse. Mr. Kroll has since modified such behavior that's no longer an issue moving forward. I don't think that the court would have any issue doing some sort of standardized test. However, the random test times require Mr. Kroll to miss work. They require him to possibly lose employment, and they put an already precarious financial situation in severe jeopardy. Thank you, Your Honor.
Thank you. Court heard the arguments. The motion needs to address a few things. Defense motion outlines in MCR 6.106 F and C and D. It acknowledges in paragraph 21 of the motion says MCR 106 D2D states restrictions may require defendants to seek specified treatment programs for any physical or mental condition, including substance abuse. The allegation is no substance abuse problem exists. However, that's his own reporting. The court has taken judicial notice of its prior files in the 2016. It was, and the PSI does indicate that there has been some prior use, and there was a conviction, though minor in status. It does give court some clue as to that there are some circumstances. The determined really here is whether or not court has the authority, and there was some allegations, at least, or requirements saying that paragraph 8 specifically that no court agency exists in Midland County to drug test defendant. 6106D outlines and states this. If the court determines that the release described in some rule C, which is the release on PR bond, personal recognizance, will not reasonably ensure the appearance of the defendant as required, or will not reasonably ensure the safety of the public. The defendant is charged with domestic violence, second offense. He had a prior 2016, did receive the spouse abuse deferral, but the statute allows, if he's got a second, then it could be subsequently added to a second offense, not the first time for domestic violence. So safety of the public is something for the court to take into consideration as part of it. And it says the subject to any conditions the court determines are reasonably necessary to ensure the appearance as required, or public safety of the public, which may include requiring the defendant, and then it lists A through O. A says make reports to a court agency as are specified by the court or the agency. Well, it doesn't say what the agency name has to be. Probation department here serves as pretrial services coordinator. That's court agency. So having him report could be A, just report in. That's a choice. B, not use alcohol or illicitly use any controlled substances. And these are ors, by the way, and not ands. C, participate in substance abuse testing or monitoring. D, participate in a specified treatment program for any physical or mental condition, including substance abuse. E, comply with the restrictions on personal associations, place of residence, place of employment, or travel. And then you could take their passport, you could have them be in a curfew, you could have them seek employment, begin education programs, or remain in custody of a responsible member of the community. Or K, not to possess firearms or dangerous weapons. L, specified premises or areas to not to assault, beat, molest, wound named persons or person. And comply with any condition, limiting or prohibiting contact with any named other persons. And satisfy any injunctive order made or a condition release. Or O, comply with any condition, including requirements of money bail as prescribed in E, reasonably necessary to ensure the defendant's appearance as required and the safety of the public. So I don't read in here that the court actually has to run any testing program, that the court has to be responsible. So as the allegation is, the court has no agency exists in Midland County to drug test the defendants. It doesn't say that in these court rules. It says I can order them. It doesn't say it has to be court run. There's no place in there that says it has to be a court run agency. No place in there that says it has to be a drug, that has to be a court run services. And so I wanted to make sure I addressed that. I just don't see it in there. The question then becomes if there's an issue regarding too much cost. The defendant makes good money, $23 an hour plus overtime. He lives above his means. He has no money left over at the end. That's not a determination for the court to make. I mean, we have to take into consideration ability to pay. When ability to pay takes into consideration how many hours a person works, how many children they may have, whether or not they're on benefits or not on benefits, those types of things take into consideration. Indigency is different than if someone has a spending issue. He's borrowing money to buy a vehicle. He could have paid for a vehicle. He's borrowing money for internet services or some of the others. When you have some things, I'm not saying that he's being extravagant in any way, but the issue is that's not a determination for the court to look at. Otherwise, everyone who lives above their means of what they're making would say, I just can't test. That would include people who have a drug problem or an alcohol problem, if I were to follow that logic. So I'm not doing that. He has a good job. He makes good money. He has high expenses. Unfortunately, he's got some medical things, and I'm not saying those are wrong or inappropriate, but those are things that are functions of him making decisions in life to the best of his family's comfort, safety. But that being said, it wasn't ordered because he has no money. Whether or not someone's required to take an intake and color line testing, the defendant's arguing that submitting to color line testing and pay a third party violates Court Rule 6106 F3 and says that nothing in Rule 7 C through F may be construed to sanction pretrial detention or sanction determination of pretrial release based on race, religion, gender, economic status, or impermissible criteria. Well, nothing was done to order him to do that because of his race or his religion. Don't know his religion. Nothing's here regarding his gender or his economic status. We didn't say because he's poor, we're going to have him do this. Because he doesn't have any money left over, we're going to have him do this so that he has to remain in jail. We ordered it because there was concerns. Court's experience has been is that though some people may drink alcohol and not be violent, many times people who it doesn't help the relationships and it doesn't help the anger issue. And so, yeah, he's got an MIP, but he's disclosed at the last time he was on probation that he has abused substances in the past, and maybe he's got it over with. Hope he does. He's got young kids that depend on him. He's got a very dangerous job that he's got to do, and it sounds like he's doing really well because he's the manager of it. You can't be the manager of it unless you've done really well. So he's working hard. He's making changes. But there's an old saying that says, trust but verify. He's not drinking. It should be easy for him to pass. And I get it that he's got remote locations. We do try to accommodate. It's really hard for him to find places to go. We could probably have him do the breath test with the portable unit. The problem is it costs more, and I'm not certain that that's a really good answer either. But this isn't his first go round, and on a violent crime, and he's innocent until proven guilty, but the court can take into consideration the nature of the charges, the serious nature, and he's looking at up to 1 year in jail as a maximum penalty. For the court to make its determination, it must distinguish and make determinations. Now, whether or not it can be show cause contempt is some type of violation of his due process right. And there's two ways to look at that. The 14th Amendment, the Constitution, says you can't deprive liberty, life or liberty without due process of law. And then there's procedural due process, as an individual's right to be heard and noticed. Here, there really is no violation of either of the due process rights. Under Michigan law, a court's decision to setting bond is a court order. Specifically, a bail decision is an interlocutory order, according to People versus Edmond, 81 Mishap 743, 1978 case. The plain and ordinary definition of word order clearly encompasses bond conditions. When a court determines that a release on personal recognizances will not reasonably ensure the appearance of the defendant is required or will not reasonably ensure safety of the public, the court may order pretrial release of the defendant on condition of combination of conditions that the court determines are appropriate. In this case, the court ordered that part of his conditions of release would be submit to color line testing. Now, the defendant argues after he's already violated it that requiring him to pay for his own supervision prior to conviction denies him due process rights. Well, it is not. In regard to criminal statutes, procedural due process is generally satisfied by providing a defendant with a reasonable notice of the charge against him and an opportunity to be heard and present a defense. Here, he's known it, we presented it to him, and he is making his arguments. It's not a substantive due process problem either. 6106D permits a court to require a defendant to satisfy bond conditions, and it permits the trial court to revoke the bond of a defendant who fails to comply with conditions of release. Defendant's bond conditions require him to appear for court proceedings. The underlying purpose of substantive due process is to secure the individual from the arbitrary exercise of governmental power. Because the trial court's decision was permitted by court rule, the defendant was not subject to an arbitrary exercise of governmental power. He did not suffer any substantive due process. Question regarding whether or not the court imposed de facto monetary bond in 6106. Also, I'm not finding that. It says he has to pay for his own color line testing. There are agencies that would help. He can qualify for Far Brighter Tomorrow. There's other agencies that he could ask for assistance because with a domestic violence second offense, we made the determination that he should be in jail. Plus, he's not in jail, even though he's not complying. That in itself is saying that we're not holding it against him. But the problem becomes is that if he continues, I will revoke his bond. So I do have a written opinion that I will put here, but in essence, the court is making the determination that the pretrial release and modification in terms of his bond to remove the requirement of randomized testing is denied. We'll allow him to change it. It's easier for him, but if he's cutting trees, I don't know if he's going to be able to get in and out or if they're going to have power to be able to blow into the unit. If he talks to his pretrial services coordinator and he finds a place, there are other mechanisms. If we're worried about him drinking alcohol, and I am, at least now he's saying he's cured. I hope he is. He could do the scram tether, which is attached to him. Then he doesn't have to worry about it. But that's a lot more money. So I'll let him figure out how he wants to deal with it. But if he continues to violate it, I'll revoke his bond. I get it. His risk, though, is when he's cutting trees, he's got to take a look at all of the circumstances around him, whether the power lines there, are there other houses there, are there people in the vicinity, is there water nearby, all of those things he takes into consideration. The court takes a similar thing into consideration. Is there someone else that was potentially injured here? Are there children potentially involved that may see this? Was there any issue or evidence of alcohol abuse in the past? The answer to each one of those is yes. And so let him go on bond, let him continue to make money, let him continue to go to counseling, not be in jail is a good thing. We just want to make sure that he's not drinking because I don't think that would make him a better person. So he's telling me he's not drinking. Great. Usually we start people at the lowest level of testing. And then if they mess it up, then we increase the color. Or I don't even think they use colors anymore. I think they use shapes. But
Your Honor? How would you like to proceed on the violation hearing?
Well, I'm going to presume that he's an acknowledgement. He doesn't think he doesn't have the money to be able to pay for it. So let me ask with Ms. Branson real quick. Ms. Branson,
Yes,
good.
good afternoon.
Spend your most recent interaction with Mr. Kroll.
Your Honor, I have not talked to Mr. Kroll lately. I'd be happy to give the court an update as far as pretrial service goes, if you'd like.
Could you?
Okay, so Mr. Kroll had a counseling appointment for a domestic violence intake set up on July 1st. He failed to appear for that. He didn't wake up until noon that day and didn't make the appointment. Also, as far as his testing goes, he's made zero effort and even attempting to call the testing program to know if he has to test or not. He hasn't called since June 24th when he missed that test that day. So
Okay,
really,
so
he's made zero effort towards pretrial services.
Hang on. So what you're saying may be news to Mr. Kroll. It's not to me. You're saying that you have the ability to look into the portal or some computer to even see if he's called.
That's correct.
And how is it that you do that?
We have an online system that we use that any defendants that are attached to us for pretrial services or probation, we're able to click on their individual name and it brings up kind of a spreadsheet basically showing if they've called, when they call, what number they call from, whether or not they were called to test, whether they missed a test, those sorts of things.
And you're saying he hasn't called in since June 24th, which is a little over a month.
That's correct.
And you've had no contact with him?
Your Honor, I talked to him, I believe, at least after the last hearing. I had given him more information on the funding sources, but I have not talked to him since that point.
What funding sources?
Your Honor, I gave him information on For Brighter Tomorrow as well as the MIC4 funding sources. I told him I wasn't guaranteed that he would qualify, but he could certainly contact those agencies to see if they would help pay for a portion of his testing and counseling services.
Have you had any indication or concern that he's had been any violent or aggressive behavior towards anyone?
Your Honor, I have not received any information regarding that.
Mr. Swinski, are we aware of any inappropriate contact or any concerning behavior?
In review of my notes today, I did not see that was documented anywhere, Your Honor. Thank you.
Okay. Mr. Durantz, I am going to deny your bond request to modify. I would like to be able to talk to your client just directly to give him a decision as how he wants to do it. May I address him directly?
Absolutely, Your Honor.
Mr. Kroll, you work for a tree cutting business, correct?
Yes.
So would you bid something if I just told you that I had a couple of big trees and I want you to tell me how much you're gonna, without ever taking a look at it, taking a look at the neighborhood, taking a look at even if the trees are on my property, would you bid that?
Probably not.
Yeah, lay eyes on it, right?
Yeah.
Be foolish to do that. I don't know the outcome of this case. We may have a trial, you may be found not guilty. We may have a trial, you may be found guilty. You may get a plea agreement to something reduced. I don't know the outcome yet. But I got to reasonably assure the community and the victim in this case, because you are charged, that they're safe. And the way that I was doing that, rather than just letting you sit in jail, was to say, stay away, don't drink, and make contact now and again. And you've not done it. I get why you got a job that's not around the clock. I get why you might sleep till noon. You might be working till 4 in the morning, 5 in the morning. You may work 24 hours a day. These big storms come through. You're gone. The fact of the matter is, you got to do your job. I got to do my job. And so I think in order for the community to be safe, that you need to test. If you're not drinking, that should be easy. You should test negative. But if you're not, it'd be like me making a bid on a job that I never see. You might be telling me the truth. I might be telling you that my trees are only 10 feet tall, but I might be a terrible guess at the height. It may be 10 feet around and maybe 100 feet tall right in the middle of a neighborhood with playground with a bunch of kids at it, right?
Yeah.
You're telling me that you're not drinking and everything's good to go. I'm telling you that in order for you to stay out, you got to do this. You got a choice. I can revoke it, and I will. I'm going to give you this one more opportunity to make contact and do the testing. I'm willing to change the type of testing. It costs a little more if you want to do the sober link, but if you want to do the sober link, and if that's really more of the issue in the alcohol, you can do that. That's, you just keep it on you. You blow 5 times a day. You don't ever have to leave your job. You blow right where you're at. It's more, eventually, if you keep missing tests, then we order more. It eventually ends up being about the same cost. But I'm saying for me to be comfortable that you're out in the public and no one else is going to get hurt by you, then I want you to do this testing. If you don't do it, I'm revoking your bond. Then I know you're not going to harm the people that are alleged to be the victims in this case, and you're not going to be drinking because you'll be at the Midland County Jail. Pretty simple. Do you understand?
Yes.
Ms. Branson, when would the next time you would need to talk with him or interact with him?
Your Honor, I'd be happy to talk to him as soon as court is done. I can even talk to him here since he's in person. My only question for the court is the court still ordering that he complete that domestic violence intake at JNA and follow any recommendations of that?
I am. I'm not made a modification because you already had a domestic violence conviction that you pled to. So this is the second one. So that's another one where I'm just like, I might not need it, but I want to make sure if I'm telling the community, I think you're a safe guy to be out in the community, I want to have something to back up. And they may talk to you and say, this is a terrible, bad misunderstanding. Mr. Kroll has changed significantly. I know the people at JNA. If you've done well, they're great advocates for you. If you've done terrible, they're the worst person you should have. They're good people because they shoot it as it is. They will talk with you and make an assessment. And sometimes, as strange as it may seem to you, sometimes they tell us there's nothing more we need them to do. But I'm not the expert. You need to go see the experts. If you don't, then it's you telling me that you'd rather be in jail than not working at all.
No.
Do you understand?
Yep.
Okay. Anything else we need to place on the record, Mr. Durant?
Not at this time, Your Honor. Thank you.
Mr. Swinski?
No, Your Honor, thank you.
Okay, I do have an order that I looked over signing. Katrina, what
Honor?
I'm going to make it, yes.
I'm sorry, what would you like this set? We hadn't set the next hearing. Would you like it as a settlement conference?
Yeah, we need a settlement conference.
Okay,
Probably 2 or 3 weeks out, I suspect, because we've got some cases that need to go ahead of this one. When's the arraignment on this?
let me look, Your Honor.
It was May 19th, Your Honor.
Okay. That was a while ago, but we're pretty backed up on some cases. So let's go 3 weeks out.
Your Honor, could I do August 24th as a settlement conference at 10:15 a.m.?
Yes.
I'm sorry, it's with Mr. Durant's 10:45 a.m., Your Honor.
10:45, and that'll be by Zoom. So we're going to let you work wherever you got to be as long as you got phone. Or Midland County Jail if you're not following the rules. Either way, you'll be here.
Yep.
Okay. All right. Anything else, Katrina?
Not that I can think of, Your Honor.
Tina Branson, is there a way that we can print off that notice and get it to him when you talk with him? That way he's got it in his hand rather than us having to mail it out.
Yes, Your Honor. If he just wants to come over to the probation window, I can get him a copy of that and go over exactly what he needs to do again.